Sandeep Parekh as well as HP Ranina. HP Ranina has actually joined us. So, Mr. Ranina, I want to come to you for a legal interpretation now. Since the final order has been passed by SEBI, everybody is asking whether or not now this case is closed.
Well, certainly it is close because I don't think anybody can now have any grievance at all because SEBI is a final authority. Now, nobody can appeal against that. Surely Adanis are not in any way involved. They have been given a clean chit. And since they've been given a clean chit, the matter ends there. And this is a question of fact. You see, you can only challenge something in a court if there is a legal issue involved. But where no legal issue is involved, it's a question of fact that nothing has been proved, that there is nothing wrong which Adanis have done. Then the matter comes to an end. The SEBI is a final fact-finding authority. And the conclusion of the final fact-finding authority can never be challenged in a court of law because no issue of law is involved.
I also want to understand now, as part of the process, will SEBI once again go to court? Because at one point of time, there was court-monitored process which was going on whereby the regulator was asked to probe these matters. So, how does this work out as a process now since SEBI has passed final order? Again, I would want to understand from legal point of view, it does not go to court anymore?
No, the SEBI's order will be filed in the court. Since it was a court-monitored investigation, SEBI will give its report to the court, and the court will therefore feel that now nothing remains. Nothing remains to consider because if actually what has been alleged has been proved to be wrong by SEBI, and SEBI being the final fact-finding authority, it will only give its report to the court, and the court will now close the matter because nothing remains to be argued. There's no legal issue involved. Factually, the Adanis have been given a clean chit that they have not done anything which is improper, illegal, or violative of any rules, regulations, or any other issue. Therefore, the matter will be filed before the court, and the court will now should close the issue. The whole case will now be closed by the court based on SEBI findings.
All right, so Supreme Court will take the final call on that, and just for the benefit of viewers, I'll once again draw your attention to two main issues whereby this order has focused. Whether the loan transactions between Adani Ports, Adani Power were routed through Milestone and River from FY19 to FY23. This was one of the allegations, and whether it should be classified as related party transactions. Now, SEBI has given complete clean chit on that front, and they have not found any violation of LODR in this matter. And the second main issue was whether there was scheme or artifice to conceal related party transactions that would otherwise fall under LODR regulations. There also SEBI is clearly mentioning that allegations were not established. So therefore, Mr. Ranina, as far as now the company is concerned, they would have been given proper hearing. In fact, a chance would have been given to Hindenburg as well to submit their appeal. As far as process for these companies and Hindenburg is concerned, there is nothing much apart from the allegations which may continue, but legally nothing remains.
No, you are right. There is no question of even allegation continuing. Because this is a matter of fact. They have found out that there is nothing wrong which Adanis have done, that there are no related party transactions. These are all questions of fact. Now, once this factual position has been established by SEBI, nothing remains. All that SEBI will have to do is to file its findings to the court. And based on those findings, the court will dismiss the petition which was filed earlier against the Adani Group. So nothing remains now. And as I said, nothing can be argued because it's a question of fact. The Supreme Court will never go into issues of facts. They only go issue on interpretation of a law, never on issues of facts. Therefore, once the factual position has been established by SEBI, which is the final fact-finding authority, nothing remains. Therefore, this case will have to be disposed of by the Supreme Court based on the findings that Adanis have done no wrong, that they have not violated any legal provision, and therefore nothing can be sustained in this particular petition.
All right, Mr. Ranina, point taken. Please stay with us. We also have Mr. Sriram Subramanian from InGovern. Mr. Subramanian, I want to understand from you what impact will have after the final order, which has been now released by SEBI. Have all questions been answered now? And more importantly, what happens to the other kind of allegations which were leveled against the group, and more importantly, other companies in the ecosystem?
Good evening. I think that puts to rest specifically with respect to the Hindenburg allegations, because that is the remit of the SEBI order. The last of the Hindenburg allegations with respect to the Adani group on the related particles. If there are other cases going on with respect to the Adani group, that is a different matter altogether. Firstly, whether it is in the purview of SEBI, etc. For example, there is the SEC, some investigation happening, etc. So that is a different jurisdiction, different regulator. At least as far as these Hindenburg allegations go, SEBI's order is sort of puts the final nail in the coffin. Since the past 2.5 years, it has been pending anyway, and the chairman of SEBI also has changed. So to that extent, it's I would think a positive for the Adani group.
It is definitely positive for Adani Group, but more importantly, Mr. Subramanian, how should we see this case as a whole, as a learning? Meaning, there were many allegations, the market fell, the brunt was borne by not only one company but the whole market. So overall, what learning one should have, and overall for even for government, do you think this case becomes a kind of precedence on unsubstantiated or unleveled kind of allegations which actually does not merit any kind of facts which are there, as Mr. Ranina was also mentioning that whenever SEBI comes with order, these are facts which have been placed in public. So all these answers have been given, and what are the learnings according to you?
I think the biggest learning is, see, there will be short sellers, there will be people who will be coming out with reports, there will be, so it has to be taken in the merit of those allegations. So unnecessarily in January 2023, we also put out a report saying that it has unnecessarily been politicized, it has unnecessarily been taken to the Parliament, the Supreme Court, PIL, etc., where there is a regulator of the stature of SEBI, which is empowered to investigate on its own, to look into the allegations and arrive at conclusive action. Why should other stakeholders in the market take it all the way up, politicize it, take it to Supreme Court, etc.? So there is a regulator. This is a capital markets issue. If there is merit in the allegations, the short seller, there is nothing wrong with short selling. And that has been seen again now with the Vedanta case. So there is nothing wrong with short selling. A short seller has a position, and the learning is there will be various facets or various hues of investors across the world, and India is an open capital market. It has a regulatory system in place for capital markets regulation, and it has to be within the remit of that one needs to view these allegations and give the regulator enough, I would think, weight or enough credence. The regulator SEBI has acted in this matter also, though it has taken some more time than it possibly could have done with. I think the conclusions are fairly positive for the capital markets as a whole.
Right, point well taken. Mr. Ranina, I want to understand from you, this case will act as a precedence for any such instance in the future? Mr. Ranina, am I audible?
Yeah, you are audible. You are audible. Can you hear me?
Yes, you are very much audible. So I wanted to understand, will this case be a precedence now?
No, this won't be a precedence because every case depends on the facts of each case. So here the SEBI has found that the allegations are baseless, without any documents and without any substance. And therefore, they have taken the view that these allegations have to be now put to a close. But in other cases, the facts may be different. So a precedent can only be if the facts are similar. If the facts are not similar, it's not a precedent because every case depends on its own facts.
Right. As far as the shareholders' activism is concerned, while as a regulator that is always welcome that even the minority shareholders gets right, they raise questions. But with malified intentions or somebody who is knocking the door just for the markets, keeping in mind, or somebody is a short seller. How do you see, Mr. Subramanian, in this particular case whereby Hindenburg, and as it has been alleged by Adani Group also several times, what is your take in this matter?
See, globally, short sellers are a market participant. So India, in this case also Hindenburg, because it's a high-profile company, high-profile group, so that's the reason there was probably more credence given to it, and the markets cross the. But we have to see the merit of the case, Hindenburg. There will be short sellers. We should be welcoming of short sellers because short sellers would be correct also in some cases, could be wrong also in other cases. We don't know. We as other observers or other market participants have to view the merit on the allegations on its own merit. Even the regulator has to do that. And as Mr. Ranina said, in this specific case, the allegations turned out to be wrong. But in some other case, maybe the short seller could be correct. So, and the short seller has an established position that they make it upfront that they will have a position in that stock and they will benefit from the stock price falling. So to that extent, I think they are transparent, being transparent. So we should be welcoming of short sellers. We cannot be banning short sellers. In fact, if anything, more short selling is required. But one should just view it from the perspective that they are another market participant and leave it at that.
Definitely a point well taken. They are the market participants, and for now, the fact says that SEBI has cleared two major allegations which were leveled against Adani Group, and for now, a kind of a clean sheet comes in favor of Adani Group. But gentlemen, thank you so much for joining it this hour with your views and explaining to our viewer the rationale of SEBI order.